We had standing room only last year. Or both of them. It was freaking me out. No problem. Alrighty, it's a little past 1, so let's get this show on the road. My name is Brent Johnson. I work at Washburn School of Law, and my co-presenter is Manuel Ocasio at the University of Maryland School of Law. My segment of this presentation is how we're using the high-tech courtroom at Washburn as a predominantly classroom type environment. Basically how it works, to use your courtroom as a classroom, I've found that you need to do these things. First off, the class that you're going to have in the courtroom, it must meet in the courtroom every session. You've got to immerse the students in this environment. You have to train your faculty on how to use the technology. Without the faculty who are the instructors, if they do not know how to use all of this stuff, it's not going to go off very well. Students must have hands-on instruction. They must actually touch the Crestron. They must actually figure out how to source their laptops. They must do it all themselves. And then in conjunction with that, there's a lot of one-on-one interaction you as an instructional technologist or an instructional librarian will have to do with the students. One-on-one interaction with the students or in a small group setting is probably key as well. In terms of the class meeting in the courtroom, this is imperative. Your once a semester whirlwind tour isn't going to cut it. Your final argument at the end of the semester, that's not good enough because you're not going to learn how to use the high-tech facilities in a courtroom in one session. You may get a broad brush of what you can do, but well, you'll forget it the next day. And they're going to come back to me the next semester and the next semester and the next semester. So you've got to have a class that meets in there every time, once, twice a week, all semester long. It's important to do this because the students will become comfortable with the surroundings. They'll know what's on the podium. They'll know how to push the buttons, all the bells and whistles. They'll know how to make it work. They'll become familiar with the interaction between the technology and the advocacy skills as a lawyer. They'll begin to understand when you use a PowerPoint presentation to display evidence when to use DVD, deposition testimony, and when, no, that's probably not good. We're going to go low tech on this. We're going to walk up to the jury. We're going to put our hands there and just talk to the jury as if it's a conversation. These are things you learn with lots of time in the courtroom. And then your students will they'll start to learn some of the intangibles about being in a courtroom setting. They'll learn where the plaintiff and the defendants are. They'll be comfortable approaching the judge's bench. They'll be comfortable approaching the jury bench, and all of this. This is invaluable. These intangible lay of the land feeling of the courtroom. If you're in the courtroom every day, you're going to start to learn that. And that'll be critical for their success out in the real world. Immersion. Immersion is a key concept in this courtroom as a classroom. 3 rules of courtroom technology. Know your equipment, know your equipment, know your equipment. This is a direct quote from Robert Potraff. He's an attorney out in Manhattan, Kansas. He specializes in railway litigation, railway crossing litigation. He won a $12.5 million settlement 6 months ago using high-tech courtroom and Sanction 2 litigation software and scanning ones. And I mean, he's a character. And he said the most important thing about putting on a high-tech trial is know your equipment, not how smooth you are with the jury, not how buddy-buddy with the trial judge you are. That's all great, but if you're going to use technology, you better know it. Because if you don't know how to use it and you're fumbling around, you're going to lose the jury and you're going to look like a buffoon and you'll lose the case. He told a horror story of some trial out in, I can't recall where it was, but it was out in the sticks. And the prosecutor was wanting to use PowerPoint presentation, all this jazz, but he'd never done it before. And he didn't know how to use it. And he had to ask Potraff, how do you sync it up? How do you make this work? So guess who won the trial, right? Know your technology. Train the faculty. This will be a broken record in my presentation. Train the faculty. It's important. Image is everything in terms of image of the faculty member in the classroom. If they know how to use the equipment seamlessly, they're going to look good in the student's eyes, and that's very important. If they know the technology, they'll be able to run the class effectively and efficiently, and they'll be able to get through their semester's work much better. Keep the courtroom safe. My training checklist is 2 pages, single-space typing of stuff you need to know to make this courtroom work. And if you don't have training on all of those things, you're going to break something. Intentionally or unintentionally, it doesn't matter. Stuff is going to break, and I'm going to spend lots of time pulling out what little hair I have left trying to make it right. And then fourthly, efficient use of time. Instead of them running back and forth to my office to make things work, if they can walk into their classroom and do it on their own, they can get down to the business of teaching their class. Hands-on interaction with this. This is for the students. Hands-on. They have to get their hands grubby, so to speak. And it's also good for reinforcement. I mean, they're seeing it live. They're hearing the professor speak. And then if they actually do it, that's 3 ways they're learning. So 3 is better than 1. So you have 3 times a greater probability of actually retaining that information. If they have hands-on interaction, they get the idea of, they understand the time commitment involved in creating a high technology trial. I mean, you don't just digitize images really quick and slip them into a PowerPoint presentation. You don't just convert a VHS tape into a digital format and run it on your media player. I mean, this is all time consuming. I mean, you have to plan ahead. This takes weeks, if not months, depending on how big the trial is. So the more hands-on that they are in this endeavor, the more they understand that it's a lot of hard work. If not on their part, the people behind the scenes, legal secretaries and technologists or whoever. And with hands-on interaction, they'll know the equipment. They'll know how to use a laptop computer. They'll know how to use a document camera. Document camera, document camera, document camera. Everybody loves the document camera. One-on-one interaction. I found this is very important. Law school in the modern era is a service sector industry, so there's a certain amount of hand-holding involved in this and teaching them how to use it, and that's fine. That's fine. That's how people learn these days, so we go with it. We accept that, and that's all right. With the one-on-one, you get a little privacy with the student. I mean, law school is a competitive environment, so in trial advocacy class, they're not going to raise their hand and say, "Mr. Johnson, I don't understand how to do this," and they'd look, I don't know, they'd look stupid or whatever in front of their comrades. So it's good for them to come to me and say, "Hey, can you show me how to do this?" So they don't lose face, so to speak. Instruction for individual need. With one-on-one, they can come to me or they can come to someone else on staff and say, "Hey, this is specifically what I'm looking on doing. Help me out." It's not necessarily a broad brush presentation of the whole courtroom, but hey, I just want to know how to put a video clip into a PowerPoint presentation. Can you show me? So you can make sure that they learn what they need to know. And then finally, you're going to be able to boost their confidence. You're going to see where they're weak and where they need help, and you'll be able to show them. They'll do it themselves and say, "Yeah, attaboy, good job." Boost their confidence. What must be done to make this whole as a classroom situation work? You got to have routine maintenance of the courtroom. You must interact with the faculty. Got to train the faculty again. Train the faculty. Train the students on how to use this. Interact with the administration of your law school. And then finally interact with probably other schools and other organizations to try out this stuff, because practice makes perfect, right? Routine maintenance. This is a no-brainer. Is the projector turned off? Are the computers shut down? Are the Microsoft critical updates done on your courtroom computer? Going through once a week and going through your checklist, you're gonna find problems that you might not have realized or haven't been reported to you. There might be a problem, they can't get something to work, but they just assume it's not supposed to work. So they're not going to tell you. They're not going to come to you with the problems. You have to discover them yourself. Routine maintenance, you'll have the ability to run tests with your vendors. We have a vendor that maintains a lot of support, so with routine maintenance I can do periodic teleconferencing calls to make sure all of the high-end bells and whistles are working. So when the real show is imminent, I know it'll work. And then finally, keep fresh. My routine maintenance makes sure that I know how to use it all. Because if I go a few weeks or a month without using it, I'll forget how to do stuff too. Out of sight, out of mind, right? You got to repetition. Repetition makes perfect. Interaction with the faculty. Go around to your faculty members who might be interested, who are using it, and say, "Hey, what's going on? Could we use the courtroom for your classroom, in your class?" Trial advocacy, perfect example. You're teaching them how to be trial attorneys, how to present evidence and this stuff. Hey, let's conduct the class in the courtroom. It'll be great practice for the future. You'll talking with your faculty, you'll be able to understand the problems as they see it, what issues they have, what concerns they have. You might be able to allay some of the problems there. Meeting with them weekly, you might suggest future plans. Hey, we can do this. This might be a good idea. Or, what are you thinking? You want to do a remote CLE, or do you want to bring in an outside speaker? What do you want to do? What are your thoughts for the future? And then finally, if you knock on their door, it promotes goodwill and interest. I found that I had a problem faculty member, might be overstating it a bit, but I found that making the effort, going to his office every other day or so and saying, hey, what's going on? He appreciates that, and he thinks that I care about him, and that's the way to be. Train the faculty. Again, we're going to train the faculty. You train the faculty, you're going to ensure the greatest chance of success, that they know how to use this stuff, they know what buttons do what, and they'll look good in front of their students. You'll be showing interest on their behalf, make him or her look good. And if they look good, they have a good feeling about the courtroom, they have a good feeling about their command of the courtroom, you'll create an advocate on your behalf for the administration when it comes around to raising money for the mandatory upgrades and technological enhancements that you're going to have to do. I mean, a high-tech courtroom isn't a fixed environment. It's always moving. You're always adding and changing and new technology and this and that. So you have to have people on your side. So train your faculty. Talk to your faculty. Training your faculty, you'll reduce the damage. You won't accidentally erase something or do something wrong. One horror story, I don't know, somehow somebody got in there in one presentation setting, I wasn't around, and the video teleconferencing software was erased. I mean, not just altered, it was poof gone. So you can't imagine the nightmare getting that puppy back up. But anyway, training will ensure that your VTC program won't go poof. Train the students. Again, ensure the greatest chance for their success. They look good in all this stuff. They're going to get a good grade. They'll be happy. That's what we're there for. We're there for the students, right? It shows the students that you have interest, that you care about them, that hey, you understand that law school's rough, and hey, you're a caring person on the campus, and yeah, come into my office. We'll talk about your trial advocacy class. What are you having problems with? How can I help? Sure, I can teach you how to scan in a photograph and stuff like that. You'll be training them for the future too. This is the future in resume bullet points. I mean, this is good for their marketing. I mean, yeah, I took trial advocacy at Washburn. We learned how to use a high-tech courtroom. I can make PowerPoint presentations that'll knock your socks off. I've done Sanction 2 litigation software. This is stuff that a hiring attorney likes to hear, because not everybody has that. Not everybody has that background, so that might separate you from the pack when it comes to interviewing. And again, reduce the damage. Your VTC software won't be erased. Interact with the administration. It's good public relation and marketing for the school. You go to your dean, you go to your assistant dean and say, hey, we've been doing this. We're bringing in local talent for technological shows. We're giving demonstrative evidence presentations at lunchtime. The local media heard about it. They showed up. They photographed. We were on TV. I mean, this is good PR. That $300,000 you spent 2 years ago for your courtroom, well, hey, we're using it. We're using it a lot. We're using it every day. So therefore, hey, we'd like to upgrade. This is what we'd like. Let's see if we can maybe raise some more money, eh? Interact with other schools. Good for networking. Touch base with your your compadres. Test out your teleconferencing ability. Bounce ideas off each other. It's good practice, too. Good practice. You never know if VTC is going to work unless you use it. I was at a teleconferencing training session last week, and it was me and a bunch of military guys who do satellite uplink and all of that jazz, and they're saying, yeah, 85% success rate's pretty good with VTC, and I'm thinking, wow, if these rocket scientists are only getting 85%, I'm not doing bad at all. So practice, practice, practice. Talking with other schools and other organizations, you'll come up with maybe possible distance learning opportunities, chance to maybe put on a CLE remotely, whatever. Get student organizations involved. Our Latino Law Student Association, once a year, they link up with some remote law school and do basically How to Survive Law School, hour or two seminar. And again, talking with other schools, it's good PR. You can kind of puff your chest out and say, I'm doing good stuff, and get your name out there. Is training important? I hate to keep harping on this training thing, but with no training, someone's bound to screw something up. And well, here's my checklist of all the stuff you need to know how to do not to blow up your courtroom. And it's 2 pages long, so you need to train people on how to use all this jazz. The most frequent flyers. These are my trial advocacy class, advanced trial advocacy. We put on about once a month a luncheon and lecture series. The moot court teams use it, and then legal analysis, research, and writing. They use it from time to time as well. Trial advocacy class, it meets in the courtroom. That is the classroom for trial advocacy. They use all aspects of technology. Their trial textbook by the National Institute of Trial Advocacy, it is designed with technology in mind. It comes with the CD-ROM with documents and video images and photographs and all of the evidentiary stuff for an entire trial. So you track an entire trial through the course of the semester and learn how to display evidence. And that's basically what the courtroom environment's all about, is displaying the evidence to the trier of the fact. So they get an entire semester on how to learn this stuff. And again, it's great practice for the real world. It's like, yeah, I haven't litigated before, but pretty darn close. I did all of this. The luncheon and lecture series, we bring in local and national practitioners. Once a month, they speak to the students about one specific item of technology or one narrow aspect of litigation. Basically, it's good because it's straight from the horse's mouth. It's nice to listen to the faculty member, but it's like, well, this is a canned presentation we're working on in trial advocacy. Let's hear some war stories. Let's hear it from the horse's mouth. So it's good to hear it from alumni who are making it work successfully. With the luncheon and lecture series, I can show off the courtroom to the public. If it's a big enough speaker, the news crews will come and they'll take photographs and interview people, and that's good PR. Finally here, the tools we emphasize, technological tools emphasize predominantly the document camera, PowerPoint, the SmartBoard, and then finally Sanction 2 litigation software. My kingdom for a document camera. The document camera, unfortunately, I think at Washburn is almost overused. Because A, it's so easy. I mean, you just turn it on, you slap a book on, and automatically focuses, and there it is. But and it's effective. I mean, it's easy and effective to use, and the ability to display a three-dimensional object is good. And the zoom ability on some of the modern document cameras is incredible. Like ours, you can slap a $5 bill on it, zoom down, and you can read the individual names of the states on the $5 bill. But maybe the document camera isn't the best way to to present a piece of evidence. I realize it's easy to use. You have a photograph of a map or something, you throw it on there, but maybe you ought to take the time and scan it as a digital photograph and put it in a PowerPoint presentation or something. That way you can mark it up, emphasize it, blow up specific points of it. So I try to steer the kids away from the document camera, if at all possible. PowerPoint, it's old hat, isn't it? Doesn't everybody know how to use it? I've got second graders that are using it. I mean, it's incredible. Anything can go on a slide. So PowerPoint's great for basically presenting anything. I mean, you can put a movie in there, you can put pictures in there. I mean, we all know how it works. But it's really only great for opening and closing arguments, in my opinion, because PowerPoint is very lineal. I mean, bullet point A, B, C, D in a row. If you're going to mark up and blow up and emphasize, you have to plan your PowerPoint presentation ahead of time. So you're not going to be able to use it very well for impeachment and the like, because you don't know what they're going to say when they're on the stand. So it's not good for changing things up on the fly. If you want to learn more about using PowerPoint, check out PowerPoint 2002 for litigators. It's a NIDA publication. Good how-to book with a CD-ROM with examples. SmartBoard. Though it is primarily designed for elementary and secondary school, we have it in the courtroom, and it's pretty good. You can mark up web pages great. One of the few tools that you can actually annotate over movie files. It's not especially easy to annotate a movie file, but it can be done, and it's pretty slick when you make it work. It mimics a PowerPoint presentation in every way, but with more stuff. If you want to check out SmartBoard, smarttech.com. But the but is you have to have the SmartBoard software installed in the courtroom that you're presenting from. So I've only heard of one actual courtroom out in the real world that has it. So maybe it's not that practical of a device. I don't know. Section 2 litigation software. This is some pretty smooth stuff. The competitor is Trial Director. They're about the same price. I think it's $500 for a single copy. So a small firm environment can afford it. So it's worthwhile to train your trial ad students on Section 2 because they can actually afford it in the real world and they could probably use it. It was designed by a trial litigator for trial. Unlike PowerPoint, it's not lineal in nature. You just you import videos and documents and photos into it and create an entire presentation. And then at any point you can either call up by number of the document, or you can use a barcode one thing and just slickly go from slide to slide in any sorted orders. And there's a built-in zoom and a highlight function. You can do anything on the fly. You can do anything on the fly. Verdictsystems.com if you want more information on Sanction 2. The Potroff attorney from Manhattan tells the story of using Sanction 2 in a trial. He has this wand reader that looks like a pistol, and he's cross-examining people, and it's like, are you sure you said that in your deposition? It's like, yeah, I'm pretty sure. And boom, like a gun, Wild West shooter, he shoots the wand scanner, and the jury goes, whoa, and sure enough, he didn't say that at the deposition. So at the end of the trial, the final witness is up there, and he's been seeing this happen all through the course of the trial, and he gets the one thing going, and he goes, are you sure you said this in your deposition? And actually, he did. But the guy on the stand couldn't remember. So he goes for the gun. Are you sure you said that? Oh, maybe I didn't. But he did. But he said he didn't. So he actually snowed the guy. So it's kind of fun. Looking to the future. looking to the future, in addition to what we're doing now, I'm looking into maybe creating an actual class of core competencies. What should a law student know about technology and computing when they leave law school? What do they need to know? WordPerfect, PowerPoint, Adobe Acrobat, how to scan a document, stuff like that. Can we build a one-credit course dealing with core computer competencies? Maybe creating a class dealing with, or at least a session dealing with the admissibility of electronic evidence. There's an entire body of literature and case law on that, so that might be fascinating. I'm working on maybe getting a teleconferencing put together for trial advocacy where we remotely depose somebody and you can see the interplay between the lawyer and the respondent, stuff like that. Maybe work up some more trial advocacy CLEs, I think that'd be good, and then maybe create some distance education opportunities with other schools. So, any questions? Here's my information. If you want to call me or email me, I'd be happy to chat with anybody about this stuff. Yeah.
How long are your trial advocacy classes?
Oh boy. This year we had an influx. I think there was close to 80. They broke them up in six groups, and one would meet in the courtroom, and then others would meet in the classroom, and they'd rotate.
How many, if any, other people are helping you do the one-on-ones with them?
I'm basically a one-man show, eh? I'd say mostly outside. In class, anybody who wants to use the courtroom, they have to have signed off that they went through my generic training they went through all of the bulleted point lists on my check sheet, that they were showing how to do all of this stuff. So. Absolutely. There are some that know way more than me, and then there are others that have a fourth grade education on the stuff. So the spectrum is kind of interesting. All right, I'll turn the floor over to Manuel. You want to use that?
Everybody can hear me. Great. Thank you. Okay, this presentation is a little bit less about technology and a little bit more about what it has facilitated in our case at the University of Maryland School of Law in terms of us promoting a particular program, a court visits program. This initiative has strengthened a traditional collaboration between the academy, the bench, and the practicing bar. And it's nothing but a twist on an old idea that we have to bring the real world into the law school classroom in order to make the legal education meaningful and effective. When we consider, Maryland has a very strong clinical law program, and it's because it's mandated by the state. All students are required to achieve proficiency in practice before graduating. And it's either through participating in a formal clinic or through our legal theory and practice curriculum, which integrates experiential learning and reflection with legal theory in the classroom. A technology component is now part of that clinic's boot camp, as you will. And our clinic students, just as the students in our trial advocacy program and our first-year students taking the legal analysis research and writing component, are becoming much more adept at using technologies, just as practitioners are doing, to enhance their learning experiences and also to serve the needs of our client base. But more importantly, our community as a collective is currently engaged in considering issues of professionalism and best practices in legal representation arising from the use of these technologies, both within and outside of the courtroom. And while we've heard about the document cameras and about the technologies in specific, I will talk a bit more as to how the investment in technologies in our case, and perhaps not as much their use, has created opportunities for our students that go beyond learning to use them, but has opened new horizons in terms of how to learn to practice law, while building relationships with the bar, the bench, and the community at large. Since the University of Maryland School of Law opened the Nathan Katz Law Center in June of 2002, we have hosted several sitting courts. The U.S. Court of Appeals for the Fourth Circuit, as well as 2 visits by the U.S. District Court for the District of Maryland, the Maryland Court of Special Appeals, and the Court of Appeals for the Armed Forces. In recognition, among other things, of the serious impact of technologies in practice, and the ability of technology to serve as a catalyst for learning, the Maryland legislature actually amended its judicial statute to allow for the Court of Special Appeals to meet outside of its house at the 2 law schools in the state. The use of technology before and after the court visits was critical in providing a solid learning experience for our students. For example, briefs were available to all of our students before the arguments, and we posted them electronically on a dedicated page on our website. And in addition, Blackboard, which is our distributed learning platform, was also used to facilitate communications between students and faculty in relevant courses that were considering the issues in the cases that were to be argued at the law school. Links to specific parts of the arguments were disseminated using Blackboard, and reflective discussions using discussion board ensued using that medium as well. We also discussed and critiqued the cases and briefs live before and after the arguments, with the judges, the attorneys, the students, the faculty, and these sessions were videotaped in those courtrooms for future educational use. And as good education does, it flows every which way. Members of the judiciary graciously answered our students' questions and took our students' feedback, while our students had a unique opportunity to pick their brains, adjust after an argument, and actually comment on their particular facial expressions, which was actually a very interesting piece of that discussion. In addition, members of the bar who argued these cases listened to our faculty and engaged in meaningful discussions in matters of both advocacy style and substantive issues. And then they had the evidence, that videotape, that allowed them to reflect on their own particular advocacy style while looking at themselves from that sort of extra dimension. We simulcast the arguments to allow as many people as possible to see them, including high school students from Baltimore who could only attend due to their own curricular program restrictions to only part of the session, so we didn't want them in and out of the courtroom. But they were able to see them live from an adjoining room within the law center and discuss with their own teachers the implications of some of these cases. Needless to say, our moot court team and our trial team students took a very prominent role in putting much of these programs together for members of our community, and they did a superb job. But what were our educational goals? Well, they were basically the same that we sort of talked about. It's the integration of theory and practice, the incorporation of experiential learning in the context of the law school, creating a reflective practice and learning environment, including technology as part of that reflection, and strengthening our partnerships with the bench, the bar, and the community at large. It's interesting how technology actually integrated all of these and how it sort of permeated through them. When we say integration of theory and practice, the Fourth Circuit Continental Casualty case involved questions of venue. One of our first-year civil procedure professors designed an entire lesson, which was partly delivered on Blackboard and partly in person, and it was all centered around this case and hosted the attorneys after arguments to discuss the legal theories with her first-year students. Similarly, Judge Garbus from the U.S. District Court in Baltimore hosted pre-trial arguments in an intellectual property case involving personal jurisdiction based on internet activity. These arguments all were incorporated into our IP classes and our required first-year pre-trial advocacy curriculum. Another interesting technological case was Barcelona.com, where we integrated experiential learning into the classroom. This case involved questions of intellectual property and international law, and in particular, jurisdiction of two foreign entities, one an individual and one a person, just because we were discussing issues related to the internet. Our students and faculty participated in a 2-hour debriefing with the attorneys, including foreign trained attorneys and parties, with live translation. And our students experienced firsthand the challenges involved in practicing in an increasingly international environment where technology has real substantive implications. As fate would have it, the very first case heard at the law school last 2 falls ago, actually, was the Maryland Court of Special Appeals Black Book case. And in this one, I'll give you the actual citation: City of Frederick versus the Randall family. And because of the speculation as to what public names might have been in that Black Book, which belonged to an alleged madam, you can imagine that this case drew some interesting attention from the community and the public. We had a full house. We actually needed to simulcast all of the arguments to every room in the building because everybody wanted to be involved and wanted to see it. But the case substantively alludes to the issue of relative obscurity of court records, even though they're public. But now, because they're public and available, it creates a brand new ballgame. And our students were exposed firsthand to that particular difference that technology makes in what has been the status quo, at least in theory. But now, because of the access that technology gives us, it changes the way we do it. After the arguments, of course, our students and faculty met with the experienced appellate attorneys to discuss advocacy styles and theories of lawyering, as they did in the prior ones. The discussion with these experienced attorneys contrasted starkly, if you will, with the student attorney discussion after the Davis case before the Fourth Circuit. This was a criminal appeal. And both lawyers were relatively young. The attorneys were able to relate very well to the students and took with them a videotape of their arguments, as well as videotapes of the discussions with the professors, and were able to sort of relive that particular experience as were our students, and it was a very meaningful learning experience. After these arguments, Judge Niemeyer from the Fourth Circuit hosted 2 classes with our students on appellate advocacy following these, the visit from the Fourth Circuit. Again, those were taped and the feedback was recorded, and we used them for our trial advocacy program. We achieved our goal of integrating the schooling to the community by reaching out to a spectrum of audiences. We followed up with the attorneys to give them the videotapes. We hosted young attorneys from the Maryland State's Attorney's Office as part of their continuing legal education program. and they were able to use all the technologies in all of the courtrooms. We have 3 in order to sort of increase their skills using the technologies, and again, get feedback on how well or how poorly they did. As I mentioned earlier, we included local high school students, and in addition, local college students and alumni participated actively in these core programs. Finally, and interestingly, because it was a great, unique opportunity, one of our students was able to argue as amicus before the Fourth Circuit. In the recent visit of the U.S. Court of Appeals for the Armed Services. And this particular opportunity, which we hope will repeat itself, is partly due to the fact that we have, in fact, the technologies to be able to host these courts that we didn't have before. Again, technology rears its interesting head. The case that he argued was related to biotechnology, in particular admissibility of DNA evidence. And finally, at the suggestion of members of the bar who have argued cases in our courtrooms, the law school is now considering starting a practice of hosting attorneys to moot their appellate and trial advocates and trial arguments in our courtrooms. An experience which will undoubtedly have a positive impact on our advocacy program, as our students will actually get to see them and give them feedback. They say that they're interested in using our courtrooms because they have the distinct feeling of a courtroom, and at the same time they have state-of-the-art technology, and also give them the opportunity to watch themselves, see what works, and see what doesn't work. Just as the technologies change, so will our model for integrating them. But the seed is there, and we will work to strengthen these links and hopefully succeed. Thank you. I guess the floor is open for questions from both of us. So, yes. Indeed, you see a lot less used in appellate arguments. What's beautiful about these facilities is that they allow you to take these things from angles that before were either too obtrusive to be taken or impossible altogether. And the courts are not as resistant as they used to be because the technology is not as obtrusive either. I mean, one of the courts did allow for external cameramen to show up. But all the other courts have not. And yet they've allowed us to use our own camera people from a control booth because our cameras don't get in the way of the argument. And yet they provide really good feedback in terms of facial expressions, the slight movement, that pause that gets so much effect in your argument. That's what they capture. And that's really important to the people who are arguing these cases, be it students or be it experienced attorneys. And that's the piece that we're able to bring now that we weren't able to bring before when we didn't have these programs.
So far, the current course, the experience is totally fulfilling the aspect of the public. Your use of the students to see that later on, but no actual use of technology by the students.
Absolutely. There has not been unlike the trial advocacy classes, where there definitely is a great deal, or the MGTAL exercises, there hasn't been that level of technology use. Yes?
Mark also from Washburn. We're very fortunate to have someone like Brent go over and do a great job doing studying the immersion. I recognize that a lot of folks don't have that opportunity. It really does take essentially a full-time person involved doing the technology. Some of you may have seen the original RFQ or RFP. also would have implemented a much lighter coding in retrospect. We put in extraordinary numbers of features in our coding, in some ways more than anybody could possibly even recommend. And that kind of works against you at one point. I also would have spent more energy focusing on the video presentation angle rather than some other aspects. And we tried to do it so that any technology signal of any sort, in retrospect, we would have focused more on video. I would also focus early on, really hard and really fast, with local trials. We were also in a Court of Appeals kind of affiliation at Washburn, and there's not a whole lot of bang for the buck there. Those are wonderful folks, but the time that they're using much technology. Just kind of nature of the beast. We also, if you notice in the RRP, focused a lot on having a central core of computing do everything. Manage the signal, convert it, filter it, do all that stuff. In retrospect, I think there's much more bang for the buck if you make that a black box type of technology rather than try to use this core computing device to do it for you, because ultimately people are using that computing device in there and it doesn't serve dual purposes very effectively. And finally, I would make a strong, everybody's got to realize from the get-go that you need to spend big bucks to keep it going. Big bucks, not cheap. To give you some idea of scale, we're looking at another $100,000 in Washburn also, just to keep it rolling. So, yeah, it's just amazing how quickly it becomes out of date. I mean, it's very quickly.
Absolutely. I mean, we're looking at retrofitting, and it's a 2-year-old building. Yes.
Mr. Johnson, when you're training, do you go over much expected outcomes, or do you just say this button does this button does that, this is what you're going to get if you do this, this is what you're going to get if you do that, or do you sit down in your one-on-one and what's your expectation? I mean, what are you going to use this for? How many people are you going to educate? Is this video conference better than videotape that I've mailed to you later?
This is largely aspirational. Expected outcomes would depend upon the student. I'm going to first sit down and say, hey, what do you want to do? What are you looking to do? And then I'll try to formulate what I think is the best avenue to do that and then present that to the student. So I'll largely let them direct the outcomes. Because it's a case-by-case basis.
Yeah, but that is probably the most valuable, but I'm just wondering if, in retrospect, if you give them rehearsal time, or you give them, do you show them maybe the Monday, Tuesday, and then they're going to use the that following Friday kind of thing, or do they actually come back and practice?
No, actually they do. They come back in mass. There are some weeks that I can't even get into the courtroom to perform routine maintenance because they're practicing, they're trying new stuff, they're seeing what works, they're seeing what doesn't work. They use it for training purposes quite extensively. I've been impressed with their ability. They want to keep coming back and use it.
Yeah, once you have a very positive outcome, you're not going
the dean of the law school made us very strictly and I'll be honest with you, his presentation was really her presentation. She literally went upstairs. She lobbied the Maryland legislature in order to get the statute changed, as you probably noticed from my presentation, and she went and lobbied. So it was a pretty aggressive effort. Now she went with law professors and commissions and made a great case for what it is, which really is the building of this community of legal educators that goes beyond the idea that the only legal education you get it from the judiciary. She's hired as fellows, members of the judiciary, who teach at the law school as full-time faculty for a number of years undergrad. So, I mean,